I represent the National Council of Canadian Muslims, formerly known as the Canadian Council on American Islamic Relations, a mouthful of a name, which is partly why we changed it. My submission today echoes much of what you've heard and what you will hear, and we begin with the principle that we believe there is no substitute for the role of counsel in the administration of justice and in protecting the interests of individuals engaged with the justice system. That role for counsel, fully equipped with all of the traditional tools of our trade that lawyers use in the exercise of their purpose, has always been an essential function of all administrative processes. And the function of this is to ensure that administration of justice is carried out in open and in fairness. And it's the principle of openness and fairness that we begin with, the principle of open justice being what this Court has described as the very soul of justice. Especially in cases like this, where you have information that will form the basis of decisions that will have particularly powerful impacts on the individual subject to those decisions, the importance of counsel and in particular the role of cross-examination to test that underlying information can't be overstated. This is especially true when that underlying information is unreliable and untrustworthy, which we submit is often the case in the area of national security. And it's even more important when the subject of that information or the subjects of that information are drawn from members of a vulnerable community. In this case, though it hasn't been directly addressed by any of the parties or interveners so far, I do bring this fact to your attention that security certificates have been issued against members of the Canadian Muslim community or Muslim Canadians in an overwhelming respect, virtually in every post 9/11 case. And on top of that, this is a community that has been the subject of national security policy and priorities over the past 12 years. Now, Canadian Muslims understand the importance of public safety and national security. Indeed, they benefit from national security as much as any other Canadian does. But the point that my clients feel is important to be raised in the hearing of this matter in particular is that Canadian Muslims pay a higher cost for that security. And because of that, it's important to remember when balancing interests and defining what fairness means in this case, that we think about fairness in two respects, both with respect to the individual who's subject to the certificate, but also in terms of the general interests of society and of affected groups. And of course, my client's interest in this appeal relates primarily to this second dimension of fairness, which is a different societal interest than national security, which of course has been raised. Now, whether you do this under Section 1 or Section 7, I'm not taking a position on where that is better to be done or how that should be done, but no doubt you will be balancing interests, and I urge you to consider the interests of this vulnerable community that has been overwhelmingly affected by this nation's approach to protecting security. And the fundamental problem with the security certificate provisions at stake in this issue is secrecy, and it's our submission that it is secrecy that contributes to the reproduction of negative stereotypes against Canadian Muslims. And we know that they have been the subject of scrutiny since 9/11. We also know that heightened suspicion has fed assumptions and general patterns of discrimination in the broader society. Now, why is discrimination in the broader society, this climate of fear that Canadian Muslims have lived with for the past 12 years, relevant here? And this is because that climate of fear, those patterns of systemic discrimination that occur within the society do have a tendency and can infect institutional and administrative action. We need to be realistic about that. And we need to do everything we can as a justice system to guard against that. And it's my submission that the thing we do, the easiest thing to do, the most important part of our process is to ensure an open process with a fully equipped counsel. And whether the function of counsel is being carried out by a special advocate or by the individual's counsel, proper counsel, the problem is the bifurcation of the function of counsel. You have nobody who is able to perform the traditional role that all lawyers play when representing a client.
Who would be responsible then? I'm assuming you used the word balancing. I'm assuming that you think there's something in the process when you have just one counsel that will take into account those confidential issues, or are you saying there is nothing confidential between a lawyer and his or her client?
Yes, that's it.
That's your position. So
yes.
I was right to read this as an absolute.
That's correct.
Okay.
I agree with other arguments that have been made here today that you need to, if information is going to be used to put someone away, that information has to be checked and confronted. This Court has made very clear the importance of confronting adverse information and adverse evidence, the importance of the confrontation right for the named person or for the individual affected by the law is of utmost importance, and you can only do that through cross-examination in the form of counsel. My position is simply, it doesn't matter if the special advocate is doing that or the public counsel is doing that, as long as the person serving that function is able to communicate effectively with the individual in order to get to the bottom of the facts and present the decision maker with a full picture of the facts. That's what's ultimately the most important thing. The designated judge is not getting a full factual picture in the absence of effective cross-examination, and that certainly can't meet the test of a meaningful hearing as laid out in Sharkawi 1 by this Court.
But I don't see how we keep coming back to what's essential and what's sufficient and so on. I mean, what I'm hearing here is unless the named person, for example, knows the identity of the confidential informant, you can't have a fair hearing. Because what I've been hearing is that you've got to be able to cross-examine and find out whether this person has a grudge or this person has lied before or this person, whatever. This gets us into the realm of, we're actually going beyond criminal law in a way, but it gets us into a realm of, unless you get everything, you can't make full answer and defense. I mean, if someone wants to say that, I'd like to hear it.
Well, we tailor the rights of individuals in procedures to the implications or the impact that those procedures are going to have on them. And what we have here is an analogy to the most serious criminal offenses in the case of individuals subject to a security certificate where there is no alternative to deportation. The alternative is potentially a lifetime of incarceration. So that's the balancing that we're left with. And
sorry, I don't hear any balancing. I apologize for interrupting. I don't hear any balancing in this. There's no balance. You must give the named person the name of the informant so that a proper cross-examination can be done, whether it be done by the special counsel or the named person's lawyer.
I think it matters. I think that the answer to that question would depend if the person's going to be incarcerated for a day or for 10 years. And what we know is that security certificate detentions and the ongoing control measures can impact people for years. And in such a case, I think the justification for not providing full disclosure would need to be very compelling. I'm not sure that I'm persuaded. My primary point to make to you, and in my few remaining seconds, I will bring it home by simply emphasizing the importance that the Charter brings to government being both being attentive to the impact of its actions and also concerned about the perception. And what I can tell you is that my client has heard a lot from members of its community about concern about the perception of fairness. And it's important that the law send the important signals to those individuals of society who are meant to benefit from it. And if Canadian Muslims are to believe that the Charter is for them, that it means something to them, and that it's there to work for them, not against them, affording individuals in such a process the traditional rights that other parties subject to the state's power have in adjudicative proceedings, such as cross-examination and full disclosure, becomes of the utmost importance. Thank you.
Thank you.